Jake Hill, Tia Taylor and Chelsea Powell, you can remain seated for the moment. Saturday the 29th of April last year, the Eclipse Nightclub in Bodmin was open as usual for those who wished to enjoy a good time. It was, up until closing time, an uneventful evening. Groups of friends were there to mingle and to socialise. These included Michael Allen and others from his rugby club, all of whom had attended a rugby club dinner earlier that evening. They also included you, Tia Taylor, and your friend Tessa Saunders, who decided on an impromptu night out. There you met Jake Hill and Chelsea Powell, who had come across each other by chance earlier in the evening in Wadebridge, and who had decided to continue their evening in the Eclipse. On the evidence I heard, all in the Eclipse had a good time. But as people started to leave, violence erupted in the road outside. That violence had nothing to do with any of the three of you. There was absolutely no reason why you could not have followed the example of Miss Saunders and another in your group, Robert Santini. By not getting involved, you could have headed for home. All three of you have responsibilities. All of you have young children. You had every incentive to leave those intent on a fist fight to it. You, Jake Hill, did not. Within seconds of seeing the disorder, you ran towards it and became involved in it. Within minutes, if not seconds, as seen extensively on CCTV footage in the trial, 4 people had been stabbed, 2 of them seriously, and Michael Allen had been fatally wounded. I am to sentence you today for the murder of Mr. Allen and for wounding each of those 4 individuals, Liam Phillips, Ryan Berger, Rhiannon Thompson and Stefan Williams, with intent to do them grievous bodily harm. You, Tia Taylor, ran after Jake Hill as he made his way towards the disorder. As Jake Hill engaged with Mr. Allen, you ran over and launched an attack with your fists on Mr. Allen. I am to sentence you today for his manslaughter, following your guilty plea during the trial at the close of the prosecution evidence. That night, you went on to lie to the police about Jake Hill's whereabouts, committing an act tending and intended to pervert the course of public justice. You pleaded guilty to that offence at an earlier point in the trial, and I must sentence you for that offence today. You, Chelsea Powell, were acquitted of the murder and manslaughter of Mr. Allen. Following your conviction by the jury, I am to sentence you for an offence of perverting the course of public justice when you lied in a statement to the police about what had happened. Michael Allen's death and the wounding of 4 other individuals all came about, Jake Hill, because of your decision to carry a knife on the evening in question. This is a paradigm case of the dangers of carrying knives. Experience shows that whatever their initial intention, those who carry knives are quick to use them and with devastating consequences. There is no justification for carrying any type of knife in a public place. The knife you carried was particularly dangerous. It was a hunting knife with an extremely sharp cutting edge and a serrated area along the top of it. You had absolutely no reason to be carrying such a knife. You do not hunt. You have no need of a knife of this sort. You were a carpenter at the time, but this was not the reason for having this knife. You may have used it, as you told the jury, in the days before the incident to cut insulation, but this was not its purpose. You had been a carpenter for some time and had had no need of a knife such as this before. On the evidence before the jury, you bought the knife a few days before you used it to such devastating effect. I do not consider that you gave any real explanation for its purchase. You were to tell the jury that it was because you liked the look of it, yet you did not merely look at it. You carried it with you on the 29th of April. I reject your evidence that you carried it only because your grandmother did not want you to leave it in the house. You were spending the day with your partner and young son in the presence of other children. You could easily have hidden the knife in your room at your grandmother's house before you left to meet with them. You chose to take it with you, and rather than clip to your belt around your trousers, as you had carried it before, you chose to wear it on a belt diagonally across your chest, where it was reasonably easily seen and easy to produce if necessary. Whilst I do not find that you specifically wanted the knife because you were going to the Eclipse Nightclub, I am of the view that at the very least you liked the feel and image of being a hard man. In that you were wholly misguided. By the very carrying of that knife, with the attitude you had, you created a very dangerous situation. Further, in wearing it in the way that you were, with easy access to it, I conclude that you intended to have it available for use as a weapon should the need arise. You had not initially intended to go to the Eclipse. It was when you met Chelsea Powell, and those she was with by chance, in public houses in Wadebridge on the evening of the 29th of April, that you decided to join them and continue the evening there. Realising that you could not take the knife into the nightclub, you secreted it in a hedge opposite the entrance. You collected it when you left, wearing it as before. There was no need to do so. You live in Bodmin and could have collected it, if need be, the next day. It was with that knife and in those circumstances that you ran towards the disorder with which, as I have already said, you had absolutely no need to get involved. Within no time at all, you had pulled the knife from its sheath and used it to stab 4 individuals in quick succession in what can only be described as a spree of violence. The jury, rightly in my view, concluded that you were not acting in self-defence. I do not accept that self-defence formed any part in your actions. You may have got embroiled in a melee by your own actions, but no one else had a weapon. There was pushing and shoving in which you became involved by choice. There can be no justification for pulling your knife and deliberately, as the jury found, stabbing 4 people. The use of a knife such as that showed a clear intent to cause really serious bodily harm, which you did. Liam Phillips suffered a significant stab wound in his abdomen below his ribs, which required surgery. As his impact statement makes clear, he suffered a high degree of pain and indeed financial loss as he was unable to work. He has physically recovered well, but suffered emotionally and psychologically. The effect has been, and I have no doubt will continue to be, long-lasting, affecting his ability to socialise as he fears what may happen if he is out. Ryan Berger received a near-fatal injury to his thigh, severing the femoral aorta. Dashcam footage shown during the trial dramatically showed blood spurting from his leg. Were it not for the quick thinking of one of the doormen in applying a tourniquet, I have no doubt that you would be facing sentence for the murders of 2 men. Mr. Berger required 9 hours of surgery to use the vein in one leg to mend and repair the other. He spent 9 days in hospital and a considerable time convalescing. The impact on his life has been severe. He has experienced pain and discomfort, financial loss by not being able to work for some time, and significant psychological harm in coming so close to losing his life. He has needed counselling, and the incident has caused him to stop socialising with friends for fear of what may happen. You stabbed Rhiannon Thompsett in her thigh. You have known her since you were both children, and she has struggled to understand why you did as you did. Her injury, although far from negligible, was fortunately not so serious. She has nonetheless experienced considerable pain and found it difficult to maintain her employment in the aftermath of her injury. Stefan Williams was stabbed to the chest. Not for any reason connected with you, he is lucky to have escaped more serious physical injury. He has been affected psychologically, not wanting to socialise or go out for fear of what may happen. Michael Allen has been described by all who know him as a gentle giant. He was loved and adored by all who knew him. He helped look after his grandmother, who lived in the annex beside the house in which he lived. He was adored by his nieces, who with the rest of his family have struggled to understand and come to terms with his loss. You, Jake Hill, must face the consequences of your crimes by the sentence I will impose upon you today. That cannot bring Mr. Allen back, and for his family, his death has been life-changing, and they must always live with his loss. His willingness to help others was evident to the end. Mr. Allen was not involved in the disorder that night, but it is clear from the CCTV footage that he could see that you were. He saw you with a knife in your hand. It is highly likely that he heard people scream they had been stabbed. He may, we know not, have seen the blood gushing from Ryan Berger's leg. Mr. Allen did not jump back or run from you. He stepped forward and took hold of you in what I am sure was an attempt to prevent you from hurting anyone else. As he turned you and pushed you towards the hedge bordering the pavement, you both fell. It's far from clear, but it would seem you were on the ground together more than once. This was your opportunity to see sense, to release your grip on the knife. Instead, you used it once more, this time to stab Mr. Allen to the lower abdomen. On the pathologist's evidence, you used at least medium force. On the jury's verdict, you were not acting in self-defence, and you inflicted that fatal wound deliberately. On the evidence, I cannot be sure that you had an intent to kill Mr. Allen, but plunging a knife such as that, using at least moderate force, into the lower abdomen of another, was highly likely to cause very serious injury with a high risk of death. Indeed, within a very short time, Mr. Allen had died. Once you had stabbed him, you jumped back, but not before you asked another whether he also wanted some, offering violence to him when he told you to put the knife away. You stayed at the scene for only a few minutes. In that time, others were trying to help those injured in the carnage for which you were responsible. Eager to escape responsibility, you ran from the scene. You knew that you had caused serious injury to others, observing that you were responsible for stabbing all these people. CCTV footage shows you, not far away, calmly returning the knife to its sheath on the belt across your chest. You showed not a shred of remorse then. You have shown not a shred of remorse since. In the long period in which you were giving evidence in the trial, I detected absolutely no regret on your part. Tia Taylor, as I've already said, you, rather than following the advice and example of your friend Tessa Saunders, ran after Jake Hill towards the disorder. Other than the fact that you had been drinking a lot of alcohol, an aggravating rather than mitigating factor, your decision to get involved is completely inexplicable. An important question in your case is whether you knew that Jake Hill had a knife when you joined into the attack on Mr. Allen. Although you were very close to him at the time he inflicted the non-fatal injuries, I cannot be sure that you did. You met Hill in the Eclipse that night, when he had already concealed the knife in the hedge. Although you knew each other, there is no evidence that he routinely carried a knife, let alone that you would have been aware of that fact. Footage of him collecting the knife does not lead to the safe inference that you were aware of its presence at that time. The non-fatal injuries were inflicted in close succession, and in circumstances where those injured did not immediately realise that anyone had a knife or that they were injured. The scene was loud and chaotic. I sentence you on the basis that you did not know of the knife at the time of your involvement in the assault of Mr. Allen. Nonetheless, you willingly and aggressively joined into that assault, intending, as you accept by your guilty plea, to cause some harm short of really serious bodily harm. I accept that was initially because you saw Mr. Allen take hold of Jake Hill, but as you accept by your guilty plea, your actions were not in lawful self-defence or defence of another. You could be seen on the footage raining blows onto Mr. Allen's back when he was on the floor, including after Jake Hill had moved away. A doorman witnessed you kicking him whilst he was on the ground. You knew by the following day, when Mr. Allen's death became known, that you had played a role in it, saying as much to a friend. You should have accepted responsibility immediately and pleaded guilty to manslaughter as soon as the opportunity arose. That night, as your group moved away from the scene towards your house, where earlier you had agreed to continue socialising, you and Jake Hill were aware of the risk that Hill at least would be arrested. Rather than seeming to be horrified by what had happened, you, Tia Taylor, told him that he would have to bleach the knife when he got to your house. You, Hill, told the rest of your group they should keep their mouths shut. Within a few hours, armed police were at your door. Body-worn footage was shown to the jury of police calling for you to come outside. Instead, you, Hill, concealed the knife in an extractor fan in the kitchen and hid yourself in the loft with Miss Taylor's knowledge and consent. When you emerged from the house with your two very young children, you, Tia Taylor, told the police that Hill was not there, lying to them and thereby attempting to pervert the course of justice, hoping no doubt that Hill would not be arrested for the serious crimes he had committed. Your dishonesty set no good example to your children. It is a good job that they are more honest than their mother, and your toddler told the truth that he was hiding in the attic. You, Hill, were then arrested. Chelsea Powell, in the days and weeks that followed, the police were investigating what had happened and taking witness statements from those who had been at the scene. It goes without saying that this was a case of the utmost seriousness, and every witness had a duty to assist the inquiry and tell the truth. You were one of those who was asked to provide a witness statement. You lied through your teeth in what you told the police. You did not tell them of the presence of your brother or his friend who were potential witnesses. On your own evidence, you were aware that Jake Hill had become involved in a violent altercation with Mr. Allen and that he had stabbed a number of individuals. You told the jury that he had said so while still on the scene and looking at Mr. Allen, who was by then unconscious on the ground. You omitted in that statement any mention that he had the knife. On the evidence, I am sure that by the time you gave this statement, you were aware of that fact. Whether this was to protect yourself or more likely Jake Hill is not certain. What is certain is that you impeded the ability of the prosecution in their investigation of this serious case. Fortunately, others told the truth, and the impact of your lies in consequence did not have the impact they may otherwise have had. I turn to your sentences. Jake Hill, for the murder of Michael Allen, there is only one sentence prescribed by law, and that is imprisonment for life. That is the sentence I will shortly impose upon you. However, I am required to determine the minimum period you should serve in prison before you are eligible to be considered for release on parole. It is most important that you and everyone concerned with this case should understand what in fact this means. The minimum term is not a fixed term after which you will automatically be released, but the minimum time that you will spend in custody before your case can be considered by the parole board, and it will be for the parole board to say at that time whether or not you will be released. If they say you should not, you will remain in custody. If and when you are released, you will be subject to licence, and this will be the case for the rest of your life. If for any reason your licence were to be revoked, you would be recalled to prison to serve your life sentence in custody. In coming to the appropriate minimum term, I must first decide where this case falls within Schedule 21 to the Sentencing Act 2020. There are no factors which would place this case within paragraphs 2 or 3 of the schedule. I am satisfied, however, that you took that knife to the scene of the murder, intending to have it available as a weapon should the need arise. Therefore, by paragraph 4 of the schedule, the starting point for the minimum term for the murder of Mr. Allen is one of 25 years imprisonment. I accept the submission that you did not intend to use the knife until you saw the violence outside the club, and will make some modest allowance to reflect that fact. None of the aggravating factors in paragraph 9 to Schedule 21 apply in this case. That is not to say that there are no aggravating features. This was an offence which took place in public, at night, and in the context of ongoing disorder. You, Hill, were under the influence of alcohol. You sought to conceal the knife afterwards and hid from the police in Tia Taylor's loft. You are now 25 years of age. You have previous convictions, including in 2016, when you were sentenced to 3 years detention in a young offenders institution following your guilty plea to an offence of attempted robbery and possession of an air gun with intent to cause fear of violence. You were cautioned when a youth for possession of a lock knife. These offences show your previous association with weapons and are an aggravating factor in this case. When assessing the extent of that aggravation, I bear in mind that these were nearly 8 years ago when you were very much younger. I find mitigating factors in the lack of premeditation and the fact that you had an intention to cause serious bodily harm rather than to kill, although the nature of the weapon and the site of the wound made death virtually inevitable. I take into account all that your counsel has said on your behalf. You are still a relatively young man who experienced a difficult childhood with parents who are sadly both addicted to Class A drugs. You lost your mother not long before the 29th of April last year. But you were not without prospects. You had trained to be a carpenter and were in work at the time of the offences. You had a young son and had learnt that weekend that your partner was pregnant again. This should have been the focus of your life, not carrying dangerous weapons on public streets and using such a knife on others. Inevitably, by reason of the sentence I must pass today, your son will grow up without your presence or support. Others in your family who love you will inevitably miss you in their lives. That is the consequence of your own behaviour in April last year. Balancing such aggravating and mitigating factors as exist in this case, were I sentencing you for the murder alone, I would have imposed a minimum term of 23 years imprisonment, less the time you have served on remand. But I am not sentencing you for the murder alone. I must also sentence you for 4 offences of wounding with intent to cause grievous bodily harm. I approach your sentence by increasing the minimum term to reflect that further offending. Insofar as the sentencing guidelines for those offences are concerned, I agree with the prosecution that each of counts 4, 6, 9 and 11 involve high culpability on your part by reason of the use of the knife. Count 4, the wounding of Liam Phillips, falls within Category 2 harm, as grave injury was caused. Count 6, the wounding of Ryan Berger, falls within Category 1 harm, as life-threatening injury was caused. Counts 9, the wounding of Rhiannon Thompson, and 11, the wounding of Stephen Williams, both fall within Category 3 harm. These categorisations would individually result in considerably higher sentences than I will impose in this case. That is not to understate the severity of your offending, but because I must take account of totality and the fact that the entirety of the uplift will have to be served before you become eligible for parole. Jake Hill, stand up. For the murder of Michael Allen, I sentence you to life imprisonment. You will serve a minimum term of 28 years, less the 348 days you have served on remand. That comes to 27 years and 18 days before you are eligible to apply for parole. Thereafter, it will be for the parole board to decide when, if ever, you should be released. If you are ever released, you will remain on licence for the rest of your life. On count 4, I impose a sentence of 7 years imprisonment. On count 6, 12 years imprisonment. On counts 9 and 11, 5 years imprisonment on each, all to run concurrently with each other and with the sentence of life imprisonment on count 1. If the surcharge applies, it can be drawn up in the appropriate amount. You may go down. Tia Taylor, in your case, I have to consider where the offence of manslaughter falls within the relevant sentencing guideline. I have considered your counsel's submission that your culpability falls within the lowest category, but I do not accept it for the reasons I have already set out. Even if you did think when you ran to Jake Hill's assistance that he was under threat, it is plain from your actions as seen on CCTV that could not have been for more than a few seconds. You did not have a weapon, and it cannot be proved that you knew of Mr. Hill's knife, but you enthusiastically engaged on an assault in raining blows upon Mr. Allen when he could not defend himself, continuing even when Hill had stopped. Your intent was plainly to cause some harm. I place your culpability on the cusp of categories C and D. The offence is aggravated by your intoxication at the time of the offence and by your behaviour afterwards in advising Hill of the need to bleach the knife, and later by lying on his behalf. I take care not to double count that latter factor, which is also the subject of count 13. Your guilty plea to manslaughter came late in the trial, after the close of the prosecution case, and after your counsel had made an unsuccessful submission of no case to answer. I have considered whether, given the timing of that guilty plea, I should afford you any credit for it. I accept that you need not have pleaded guilty and left your guilt to the jury for them to resolve. In my view, standing up to what you had done requires some recognition, and I afford you in the region of 5% credit for that plea. Turning to the guideline for offences of perverting the course of public justice, I find this offence to fall at the higher end of Category B culpability. This is because factors are present in Categories A and C, which come close to balancing each other out. The underlying offence as one of murder is the most serious, but your actions were equally unplanned and limited in scope and nature, as well as unsophisticated. The seriousness of the underlying offence requires an uplift from the overall category in which the offence falls. The offence, in my view, falls within Category 3 harm, as in the event there was limited impact on or delay caused to the administration and course of justice. Standing back, this offence falls, in my view, to the top end of Category 3B. You pleaded guilty to this offence at an earlier stage of the trial. I afford you in the region of 10% credit for that plea. You are considered by the probation service to be at low risk of reoffending. I agree with that. I also consider you to be at low risk of causing another serious harm. You are now 22 years of age. You are a single mother and sole carer to 2 very young children. Your thoughts should have been with them on the night in question. It's for you to set them a good example in life. Instead, their mother now has a conviction for manslaughter. They have been cared for since your remand into custody by your parents. You intend to reside with your children and your mother upon your release. You are still young and of previous good character. I take into account all that I have read in the pre-sentence report, the insightful letter from your father, and all that has been said by Mr. Hughes on your behalf. It is clear from the pre-sentence report that you had a difficult childhood, which led to a lack of proper schooling. You find yourself a mother and sole carer of young children very early in life, and I accept, other than your behaviour on this night, you are doing your best to provide them with the love and care they need. You have been on remand at a prison a considerable distance away from Cornwall. Those distances have meant that you have seen little of them. They miss you, a struggle to understand where you are. Your parental responsibilities meant that you rarely socialised. Your opportunity to do so on the night of the 29th of April led to you drinking far more than was responsible. As I have said, this is an aggravating factor in your case, but it is explicable by reason of your life and circumstances. It is clear that you are ashamed of your behaviour, and I accept that you are genuinely remorseful. Your father speaks of you never being able to forgive yourself for the part you played in the moments before Mr. Allen's death. You clearly have potential. You've used your time in custody to the best possible advantage, working and studying. You are hopeful of gaining a place at university in due course. I very much hope that you do, and that you become the role model your children deserve. You have undertaken counselling to try to better understand the choices you made in the early hours of the 30th of April, to try to make sure it never happens again. Your father speaks of how much you have matured through this investigation and trial. Dealing with the manslaughter first of all, I begin with a notional sentence after trial of 3 years imprisonment. For the aggravating factors of intoxication and advising Hill of the need to bleach the knife, I increased that sentence by 6 months. You have significant mitigation in your good character and the fact that you are a sole carer to 2 young children. I reduced the sentence by 12 months to reflect that and your other mitigation. I afford you in the region of 5% credit for your guilty plea. This means a sentence on count 2 of 28 months or 2 years and 4 months imprisonment. For count 13, I take a notional sentence after trial of 12 months imprisonment. I find no aggravating factors. Taking into account the same mitigation and with an eye to totality, I come to a sentence of 9 months imprisonment. I afford you in the region of 10% credit for your guilty plea, coming to a sentence of 8 months imprisonment. This is to run consecutively to the term already imposed, making a total sentence of 3 years imprisonment. Tia Taylor, stand up. On count 2, for the manslaughter of Michael Allen, I sentence you to 2 years and 4 months imprisonment. On count 13, for doing an act tending and intended to pervert the course of justice, I sentence you to a consecutive term of 8 months imprisonment, making a total of 3 years. You will not serve the entirety of that sentence. You will serve 1/2 of it, whereupon you will be released on licence. If you commit any further offence or otherwise misbehave whilst on licence, you will be recalled to serve the rest of that term. If the surcharge applies, it should be drawn up in the appropriate amount. You may go down. Chelsea Powell, in your case, I must apply the same sentencing guideline as for Miss Taylor for the offence of doing an act tending and intended to pervert the course of public justice. Applying that guideline, I consider your culpability to be high, falling within category A, as the underlying offence is very serious. I do not consider that your conduct was either limited in scope or unsophisticated. You were asked by the police to assist them several weeks after the event. You knew that Jake Hill had a knife and had said to you at the scene that he was responsible for stabbing all of these people. You knew that he had been engaged in an altercation with Mr. Allen and that Mr. Allen had died. You concealed all of that from the police in the witness statement you gave. As for harm, I consider that the offence falls on the cusp of categories 2 and 3. There was some impact on the administration of justice in that the investigators were deprived of the information that you had as to the actions and words of the man who murdered Mr. Allen. Time was expended taking that misleading statement from you. That said, the investigation was fortunately not significantly impeded by your false statement. I find no aggravating factors. I accept that you are at low risk of reoffending and of causing serious harm to others. You are now aged 22 years. Absent a caution administered a very long time ago for a totally different offence, you are of good character and I treat you as such. You have further mitigation in that you are the sole carer of 2 young children who are currently being cared for by your parents. As with Miss Taylor, those children look to you to set them a good example. By the commission of this offence, you have failed them as well as yourself. As I say, they have been cared for by your supportive parents since you were remanded into custody, with whom you intend to reside when you are released. I take into account all that I have read in the pre-sentence report and all that has been said by Mr. Henley on your behalf. You are still very young and find yourself on your own, responsible for others. As with Miss Taylor, I accept that you were doing all you could to care and provide for your children. You and they should be able to rely on their father for support, but you have been the victim of domestic violence and have obtained a restraining order to prevent him coming to your address. You also struggled at school and turned to cannabis use at a young age. I am encouraged to read that you intend to continue your abstinence from that drug upon your release. You too have used your time in custody productively, undertaking a number of courses and gaining a qualification. In your case, I take a notional sentence of 18 months imprisonment. I reduce that by 3 months to reflect your mitigation. Stand up. The sentence of the court is therefore one of 15 months imprisonment. You must serve half of that sentence before you are released on licence. If you reoffend or otherwise misbehave, you will be recalled to prison. By my calculation, given the time you have spent on remand, that will result in your immediate release. Sit down for the moment. Mr. Cotter, I wish to pay my condolences to the family of Mr. Allen, who was plainly a man of exceptional qualities. I thank them for their dignity throughout what I know has been a very difficult time and trial, and very much hope that in some way they can move forward with their lives. The investigation into this case took considerable care and skill. I wish to commend D.I. Rossen, the Senior Investigating Officer, D.S. Holly, Deputy Senior Investigating Officer, D.C. Norrish, the officer in the case, Mr. Cobb, the Disclosure Officer, and D.C. Critchley for his considerable work on the CCTV evidence, which proved of the utmost importance in this case.